Hello, welcome. Today we're going to be talking about if you get sued, will you have to shut down your business? Maybe, maybe not. We'll talk about all of these things. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. Excited to have you. We go live Monday through Friday, except for holidays at 11 a.m. So please join me live to get your questions answered or anything that you need. I'm here to help. And just as an FYI, in case you didn't figure this out, just because it's something that I am going to talk about, you want answers about something else, feel free to tune in. It doesn't have to be about that particular topic if you have questions. I don't want you to feel like that's the only thing that we can talk about. We can talk about whatever you'd like. Let's get started. All right. Well, number one, let's talk about the litigation process. First, the best scenario is to try to resolve a dispute before it even gets to litigation. And not always, but that's generally the rule. And the reason why is because litigation is more expensive and it is a lot longer and a lot more stressful than if you solve it before it even becomes that problem. So that being said, that's the best, generally, not always, that's generally the best course of action. When you are sued, the very first thing that happens is you get what's called a summons and complaint. And it's just paperwork from the court that says that this case is going to be heard. And here is what the allegations of the plaintiff have against you. And then your goal, or then that's called a pleading. That's the initial pleading. The summons and complaint is the initial pleading. The next thing is, depending on how your attorney handles it, they will file either what's called a demurrer, which is basically this thing is defective or it's wrong for this reason, that sort of thing. So it's a typically procedural thing. It can be substantive, but it's generally procedural. The other thing that they can file is what's called an answer, and the answer goes through, and depending on the type of complaint, it's a general denial, and then they assert what are called affirmative defenses. In that instance, it says, well, even if we're found liable, we still are, here are the reasons why we should not have to pay or why this is not true. And so those are affirmative defenses. Now, just like in the complaint, we have to assert the facts in the complaint. You have to assert the facts in the affirmative defenses, or provide the proof of those affirmative defenses of those things. Then you move on to what's called the discovery phase. The discovery phase can be a couple of different things. There's written discovery. I'm not going to go into all of them, but there's written discovery, and then there is verbal discovery, which is depositions, that type of thing. And then after that, you can go through the motion phase, which is like motion for summary judgment that says that we agree on the facts, we just need the judge to decide on the law. Okay. Then you make it past that. So if you make it to actual trial, then you have either a bench trial or a jury trial. And at that point, the judge, depending on the case, if it's a jury trial, the juries decide the facts, the judge decides the law, and you get a verdict and you get a judgment. It can be either for you or against you, just as an FYI. And not every case is winning or winnable case. The jury trial is harder to win because you have to convince 12 people that you're right. It's also harder to defend because there can be 12 people that agree with the plaintiff. A bench trial, you just have to change one person's mind and they're the decider. It's faster, it's easier, it's less expensive because you're not worried about the jury, and so on and so forth. So that's the difference between a jury and a bench trial. Now that you have the final judgment, now either you can appeal the judgment, and there are lots more steps in this. I'm giving you a fairly high overview, so that you can kind of get a feel for the process, not because this is all inclusive. So please do not think that this is as simple as it is, because it's actually quite difficult and or complicated. So you don't want to strictly say, oh, well, this is what Taylor said. But so then once you get the judgment, you can either accept the judgment or you can appeal the judgment. And then it shifts, the burden of proof shifts at that point to say that you are disagreeing with it because of the law. The jury and or the judge at the trial level always decides the facts. At the appeal, you're saying, well, okay, these facts are true, or these facts, whatever, but the law says this, and the judge was wrong on the law, so therefore we should get it vacated. We should get it overturned or remanded back to the trial court for further proceedings is the term of art that's involved in that. Now, you only get one automatic appeal as a matter of right. That's it. One more bite at the apple to make sure that there's a legal, that the law was incorrect, and so therefore it needs to be redecided based upon the law. If the facts were not on your side and it gets remanded back, then you could potentially go through a new trial. But you don't get an automatic right to a next appeal if they kick it back down to the lower court. You can try to appeal it to the higher court, which is in California the Supreme Court. So it goes Superior, Appellate, Supreme, and they can either hear it or not hear it. Now, they don't hear all of the cases unless it's a new area of law, it's a novel area of law, and it's undecided area of law. You want to make sure that, and so this is the big view process. So as far as the lawsuit is concerned, so that's the reason why litigation can take years. Like literally, I'm in a case right now where it is taking let's see, it'll be probably we're looking at 2, maybe even 3 years before we're done with the case, depending on how things go for us. So I want you to keep that in mind. Litigation is not a fast process. The courts are terribly backed up. There's only a small percentage that actually make it through. They don't want you there. They want you to settle this dispute without them hearing it. They make it incredibly difficult on you. Discovery is a invasive and long process that can cost thousands of dollars very easily. It is not for the faint of heart, and it can be very expensive. Courts don't want you there. Just they make it very difficult on you. So you have to keep this in mind. Settling is almost always, I do use almost, the better option, just because when you settle, it's known. You're not worrying about what you're not having to convince the jury. You're not having to convince the judge. It's you get what you get and you can walk away from it. Now, sometimes you need to go to court. You need to go to the trial because the settlement just isn't good, or they're offering you something so low that it's worth waiting to get the money later from the judge in a judgment, assuming it doesn't go to appeal and all that other stuff that we talked about. So that's the litigation overview. So you kind of get a context of the process, the length of time, why you would want to settle as opposed to push a judgment or push towards a trial. And, everybody's different. People are like, well, I want my day in court. Well, yeah, if you're willing to wait and pay for it. That's really what it is. If you've got the money, by all means. I know people that sue over nothing and everything, and it's their right to. If there's a legitimate dispute, it has to be legitimate. You can't make up stuff. But, some people have the budget. There's a dispute. They don't care. They'd rather spend the money litigating. Okay, their choice. Is it ever go anywhere? Sometimes, enough that they like to do it. So it really depends on the person, depends on the attorney, how well they're willing to settle or willing to help you to settle. There's a lot of factors that go into the litigation process. So it's complex. It's something that you want to make sure that you're getting into with the best of intent, because it can be stressful and hurt you. So now that I've hopefully not scared you, but I've given you an education on the litigation process, you want to consider for a second, what would it mean to shutting down your business? Now, if you get a judgment against you, and this is, so you had the opportunity to settle, you chose not to settle, and you go to court and you lose, okay? If you get a judgment against you and you can afford to pay that judgment, so let's just say you've got the assets, so you can just literally pay out. You don't have to worry about any liens. It's just a straight pay. And you still have money left over to run your business. Then the answer is no, you're not going to have to worry about shutting down your business because you have enough money to continue after that. It gets more complicated if you don't have the assets and then they try to attach or do a till tab, or these are all different ways of getting the money out of you once there's a judgment. Not going to go into those in any detail, but that's just the idea, is that there are lots of ways to get money out of you after the judgment. So you have to be careful. Is a judgment isn't worthless, but they can attach assets for you to get that money. They can garnish your wages if you're an employee. So if your assets are sufficient to cover the judgment, then you don't have to shut it down. If your assets are insufficient to cover your judgment, then you might have to shut down. Now, if you can make payments to the judgment to get it off, to make sure that you're taken care of, then you can probably keep going. If the amount that they sued for is, there's just no way that you could ever possibly pay it because it's, millions, which, by the way, common misnomer. People think the judgments that you see in the press are overblown, and the actual average of most judgments that happen is only $75,000. That's the average. So it really depends on what it is. If you're a big corporation or it's a big, huge, grievous thing that happened, then yeah, it can be quite expensive. But the average across the nation is only $75,000. That's the average. So that means obviously there's some higher and some lower. But my point with that is what you hear about in the press, and this is why this is important to remember, are the things that are newsworthy. You don't hear about McDonald's getting sued and them paying $75,000. You don't hear about Target getting sued and them paying $75,000. Nobody hears about that. You hear about the $1 million cases because that's news. That's exciting. That's how they get your attention, right? So I want you to take away from this is that getting sued isn't the end of the world, and more often than not, you can fix it. So I don't want you to be scared that you absolutely positively, if you get sued, it's going to be the end of your business or the end of the world for you or your business. Okay. I want to give you hope because there's a lot that can happen between getting sued or a judgment and or having to pay, like years and time and just lots of different things. So keep these thoughts in mind as we're talking about this. Now, if they do a lien against your property, it appreciates at a 10% per year and can be renewed every 8 years. It's either 7 or 8 years, which means that then it compounds interest after that 8 years. So that's not ideal. So you really want to focus on paying them off. And a lien on property is a simple way of saying that, like, for instance, a mortgage on a house, then they get to be paid out of the proceeds of that mortgage or the proceeds of the sale of the home if you sell it. It's just one tool that they have in order to get the money that's owed to them via a judgment. You could pay it that way if you don't pay it any other way. Now, if the judgment is sufficient enough and you don't have the assets and you're going to go out of business anyway, and there's just no way you can do it, your business can your business can file for what's called bankruptcy. We're not going to touch bankruptcy other than to say, depending on the scenario, it might wipe out all your debts. It might not. This is a bankruptcy question for businesses. I don't have that information and I don't want to share what I don't have. The only problem is that bankruptcy in all its glory can't wipe out punitive damages. Okay, so if you get a judgment against you for compensatory damages, great. But then if you get punitives, you can file bankruptcy and your company still owes that money. So that's not ideal, obviously. You want to make sure, try to avoid punitives, which punitives are meant to punish. So for egregious behavior, willful or wanton behavior of a company that says that they just didn't care. Think Ford with the Ford Pinto. Think McDonald's with the coffee case. There's plenty of cases out there that are big, but those are the best representations, off the top of my head. So you want to think about this in that context that, compensatory damages might go away, but punitives are usually where it's most expensive, and those don't go away in bankruptcy. Even with bankruptcy, just FYI, just because you enter bankruptcy personally or business-wise does not mean that your business can't continue. It depends on the circumstances, and you definitely want to see a bankruptcy attorney to make that decision for you. Those are the 5 things that you need to be aware of about if getting sued will affect or shut down your business. First and foremost, a problem that is solved early is going to cost you substantially less than a problem that you go through the whole litigation process for, simply from the fees perspective of an attorney. I'm not suggesting that, but it's a long, involved process. And so you really want to evaluate whether it's worth fighting it for you. It depends. I can't tell you which facts is that required or what it would make sense depending on your budget, so on and so forth. So first and foremost, don't be scared. If you get sued, contact an attorney as soon as humanly possible, because the last thing you want to do is, if you can avoid litigation in its entirety, that's the best result, typically. Not always, but typically. If you've gotten value out of this video, please don't forget to subscribe and like. And remember, we go live every Monday through Friday at 11 a.m. We'll see you later. Have a great one.